Is Ms. Lopez the court reporter?
No, she's one of my interns. Tony Rieger is the court reporter. All right, so let's go on the record on cause number DC 2015974, Resson Ventures Inc. versus R. Scott Phillips. Counsel, make your appearances.
Morning, Your Honor. Jonathan Charnitsky and Kelsey Simchick of Andy Brown and Associates, representing defendants, Pact Enterprise Rule LLC, Rule 72 LLC, Tim Pound and Jason Adam Jones. Of those, all except Pact Enterprise are movements this morning.
Steve Schneider and Stuart Reynolds representing Plaintiff Resson Ventures. And we are Resson Ventures and Mr. Reynolds are respondents to the motion for sanctions today.
Okay, let's proceed. I'm sorry, did all attorneys make announcements? I think there was somebody who's not. Mr. Wiegand, did you want to make an announcement?
No, Your Honor. Like I said, my clients are parties to the lawsuit, but are not a party to this motion. I will make an appearance that I'm here if you'd like, but I'm not.
Yes, please.
Okay, Your Honor. Bob Wiegand on behalf of defendants Scott Phillips, Jim Chafin, Dynesic Technologies, and Brandon Novicki.
All right, let's go ahead and proceed with the motion.
Thank you, Your Honor. And Your Honor, as a preliminary matter, we had emailed 3 exhibits to the court prior to the hearing, and we would move, if there's no objection from the other side, to have those admitted as a preliminary matter.
So that would be, have you emailed the court reporter?
We did, Your Honor, and those would be Defendants Exhibit A, Defendants Exhibit B, and Defendants Exhibit C.
Any objection to the admission of Defendants A through C?
Your Honor, just one question for Mr. Charnitsky. Is the Exhibit A, is your affidavit, is that the same affidavit that you had filed in support of your motion for sanctions a few weeks ago, or is it a different affidavit?
It's the same as the one that was attached to the motion.
Your Honor, we have no objection to the defendant's exhibits A, B, or C, and we have also submitted exhibits to the court reporter, which we will offer as well whenever the time is right, but I presume not at this point.
Okay, so defendants A through C are admitted, and then you're offering, I guess, defendants A through.
Your Honor, what what plaintiff is offering are the following exhibits. First, the affidavit of Stuart Reynolds, 2 affidavits which were filed with the court last week. They're not marked as exhibits. They are affidavits that have already been filed and are in the court's jacket in the court's record. And exhibits A, B1 through B18, which are attached to Mr. Reynolds' merits affidavit. Exhibits C, D, and E, which are attached to Mr. Reynolds' merits affidavit. And exhibits F, G, H, I, and J. J was submitted separately by a recent email, whereas all the others were submitted together a little bit earlier this morning as well.
I don't think I've seen J yet, but okay. Any objection to the admission of those exhibits?
Yes, Your Honor. We prefer to go through those as they come up through testimony, simply because there are, I believe, 26 of them. They were emailed not long before hearing. We have not had an opportunity to go through all of them, but we have identified some authentication and relevance issues with several of them.
Your Honor, so to narrow the list, exhibits A, exhibits B1 through 18, and exhibits C, D, and E were all attached to the affidavit of Stuart Reynolds on the merits that was attached to the opposition filed last Wednesday. So all of those have been in the movement's possession since last Wednesday. I would like a ruling on Mr. Reynolds' affidavit being admitted, and those exhibits A through E that we just listed. The new exhibits F, G, H, and I are pleadings, just copies of pleadings. I'm happy to take them up with Mr. Charnitsky whenever necessary. Exhibit J is a chronology that summarizes, identifies those pleadings in chronological order. But how would the court like to proceed with respect to the pre-admission of the exhibits that have been previously produced to Movant last Wednesday as attachments to Mr. Reynolds' affidavit and our moving of Mr. Reynolds' two affidavits, one on the merits and one on attorney's fees?
I'm going to go ahead and admit those. So that's A, B, 1 through, I think you said what?
18.
18 are admitted. C, D, and E are admitted. All right, let's go ahead and proceed.
Thank you, Your Honor. Your Honor, we're here this morning on a motion for sanctions pursuant to Texas Civil Practice and Remedies Code, Chapter 10, as well as Texas Rule of Civil Procedure 13. The motion for sanctions is brought against Plaintiff Resin Ventures and its counsel of record for filing frivolous pleadings against defendants Tim Pound, Jason Adam Jones, and Rule 72 LLC. The standards that we'll be addressing this morning under Chapter 10 of the Civil Practice and Remedies Code, the signing of a pleading or motion constitutes certification that the instrument to the signatory's best knowledge and after reasonable inquiry has a good faith basis in law and fact and is not offered for any improper purpose. Similarly, Texas Rule of Civil Procedure 13 prohibits a party or counsel from submitting motions or pleadings that have no basis in fact or law and are not warranted by good faith arguments for the extension, modification, or reversal of existing law. Finally, Texas Business and Commerce Code Section 1505 prohibits contracts or conspiracies and restraint of trade and also prohibits attempts to monopolize any part of trade or commerce. Now, Your Honor, by way of brief background, before we get to testimony, because I will be testifying this morning, I will be questioned by our associate, Kelsey Simchick. But by way of a brief introduction, the suit was filed in October of 2020. It was filed against multiple defendants, none of which were our clients, meaning the suit was not at that time filed against Pact Enterprise. It was not filed against Rule 72 LLC. It was not filed against Tim Pound or Jason Adam Jones. Now, our clients were brought in November of 2020. At that time, we have significant reason to believe that there was no basis to bring in our clients, that they were brought in as part of an attenuated string of corporate relationships. Our clients have maintained throughout the suit that they know nothing of the facts underlying it. They are not part of the conduct alleged against the other defendants. And frankly, there has been no evidence whatsoever presented that they knowingly engaged in any wrongful conduct. Furthermore, the pleadings in this case back in November of 2020, the first amended petition, after it was brought, our clients brought special exceptions, claiming that the cause of action was not adequately pleaded. It did not give them a notice of the claims against them with reasonable specificity as required under Texas Rule Procedure 47. Those special exceptions were granted in May of 2021. The plaintiff was ordered to replead within 21 days, which it did. However, we do not believe that the repleading was sufficient to give notice. It did not cure the defect. There were some conversations with opposing counsel. There were a number of settlement offers that we believe demonstrate bad faith in the basis for the suit. And ultimately, upon threat of motion for summary judgment on the pleadings, plaintiff withdrew their suit against Rule 72, against Tim Pound, and against Jason Adam Jones. And so this motion for sanctions is for frivolous filing of the suit against those three defendants. At this time, I would call myself to the stand and turn it over, turn questioning over to.
Why are you calling yourself to the stand?
Because, Your Honor, there is factual testimony that needs to be admitted with respect to the settlement discussions and the improper purpose behind them.
What basis? I mean, usually settlement discussions are not going to be admissible in court. Why would we allow them in here?
Because they're not being offered to show liability or to abrogate liability. They're being shown for a bad purpose, to show that there was a bad faith motivation behind this suit to begin with. And we can brief that topic if you prefer.
Response to that?
Yes, Your Honor, we do object to any evidence about settlement negotiations because they are inadmissible under Rule 408 of the Texas Rules of Evidence. They're not going to fall within one of the permitted use exceptions in 408B. And the subjective intent that Mr. Charnitsky is referring to is actually an element of the disputed claim under their motion for sanctions. The motion for sanctions is challenging the basis for the claims that were brought against his clients, but it also asserts as a claim for affirmative relief, the movements are asserting that Mr. Reynolds and plaintiff, that their state of mind at the time that this that the claims were filed was improper. And they're trying to offer settlement negotiations as direct evidence of that state of mind. We dispute that claim. Settlement negotiations cannot be offered for the purpose of proving the validity of the claim, including the motion for sanctions.
Your Honor, the validity of the claim is moot at this point. The claim has been withdrawn.
Well, isn't that the whole purpose? Isn't your argument that their claim had no basis, it was frivolous, and that's why you brought the motion for sanctions?
It is. That is exactly our contention. However, again, it's not being offered to show the validity or invalidity of their claim. That has already been, frankly, it was decided by the court when it granted the special exceptions and acknowledged by plaintiff when they withdrew their suit in the face of a threat of motion for summary judgment. That the validity of the claim is not in question at this point. The underlying motivation behind bringing the claim in the first place is in question.
Do you have any case law that would allow you to use 408 discussions in a motion for sanctions on a frivolous lawsuit? I mean, I guess, if you look at the wording of Rule 408, why don't we all pull that up? And again, let's see. It says the court may admit evidence of 408 settlement discussions for another purpose, such as proving a party's or witness's bias. I don't think that's prejudice or interest, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. Do you have any cases that have allowed 408 discussions to be used in this way?
Your Honor, I'm sorry, Your Honor. I do not at this point. I don't have them handy. We have researched this matter and we do feel as though it's well-founded. As I said, we are happy to brief that issue for the court.
Well, the hearing's today. Do you want to withdraw your motion for sanctions at this point and then refile it if you want to do additional briefing?
If that is going to be a point of contention today, then I would say yes. I'd like to reset, and we can amend in the meantime.
Respondent, what do you want to do? How do you want to proceed?
No, Your Honor, we object on that basis because we briefed this issue. It's in our opposition. We raised the inadmissibility of the settlement communications. We cited Rule 408 in our opposition. So movement had notice of our position, but more to the point, movement has the burden of proof today. And it is movement's burden to show that the plaintiff filed its claims against the movements for a bad faith purpose, and that the claims were baseless and filed for that bad faith purpose or an improper purpose. And I assume that they're prepared today to present admissible, competent evidence. Settlement negotiations are not.
I mean, they do brief this issue. I'm showing it on the screen right now.
Your Honor, you are right now in the portion of our brief where we were explaining that they can't use it for either of the disputed claims.
And Your Honor, I would point out that the response was filed on Thursday of last week. We have had approximately 1 business day to review their response.
The response was filed on Wednesday, August 4.
Excuse me, I'm sorry, that's correct, it was Wednesday.
Yeah, at this point, unless you have some briefing for Texas cases, I'm not going to allow in the settlement discussions. We'll see how they're admissible.
Your Honor, we would request then to withdraw and refile.
Your Honor, may I be heard on that?
Okay. Go ahead.
Okay, so I didn't want to interrupt whatever search I assume you're the one searching on the screen right now.
I am, yeah. I'm just trying to pull this case back up. Sorry, go ahead.
Okay. This motion has been pending for a number of weeks, and it's a very serious motion. It alleges sanctionable conduct not only by my client, Resin Ventures, but also by my co-counsel, Mr. Reynolds, who was personally named, I believe, in the first sentence of the motion. We have spent significant time and resources preparing the 24-page opposition that has been filed and compiling substantial evidence as exhibits, attaching all of that to the opposition and the affidavits when filed on Wednesday last week. And under the Chapter 10 of the Civil Practice and Remedies Code, the prevailing party may recover fees based on the court's ruling on the motion for sanctions, which is to say that if the movement's motion for sanctions is denied, we intend, and we have asked in our opposition, for the court to consider awarding plaintiff the reasonable fees incurred responding to this motion. It was the movement's responsibility and burden to come today prepared. If they wished to have withdrawn their motion prior to the commencement of this hearing, I suppose they could have rescheduled the hearing last Thursday or Friday. But to do so at this point, to withdraw the motion, it should be either withdrawn with prejudice, or if it's withdrawn, we're going to ask the court still to award the fees incurred to date by plaintiff to respond to it, because tantamount to the argument that Mr. Charnitsky is going to make about the effect of plaintiff's non-suit of its claims against his clients in this case, which he asserts is evidence that the claims were baseless in the first place. That same argument could be used here to suggest that Mr. Charnitsky's withdrawal of the motion now, which is tantamount to a non-suit of a claim, if done without prejudice even, is an acknowledgement that the motion was not brought with a proper basis. And we have been put to the time and expense of getting ready for this hearing today. So our position is that either the motion should be denied today for lack of sufficient proof and the failure of the move-in to meet its burden of proof, and fees should be awarded to the plaintiff, or if Mr. Charnitsky is withdrawing the motion, then we still request an award of fees to the plaintiff.
So let me ask you this. I'm kind of looking at it. What, you know, I see under section 10, I guess, sanctions that you can, and I don't see a whole lot of these. I probably can count on two hands the number of times I've even seen a motion like this filed, that the prevailing party can recover sanctions. Are there any cases that allow the non-movement to recover sanctions in a section 10 motion for sanctions?
I believe that there are cases that say that the prevailing party can recover expenses. The statute specifically says so in 10.002C.
No, I see that. I'm not disagreeing with you necessarily. I'm just,
May I perhaps answer more directly, Your Honor?
yes.
I think we all understand that the statute provides for the prevailing party to recover the reasonable expenses and attorney's fees presenting or opposing the motion, which is what we are asking for.
Okay.
10.002C goes on further to say that if no due diligence is shown, then the court may award the prevailing party costs for inconvenience incurred by the subject litigation. What I believe the case law.
Yeah, you're right. You're right. I see that. I see that. You don't need to go any further. So yeah, you definitely can recover it. It says or opposing the motion, so I just didn't see that part. I guess my question here is just kind of a practical one, which is you guys can continue to fight over this. And I will say that I very rarely, I would guess I can probably count on one hand, if not one finger, the number of times I've granted this type of motion. Probably one hand, one finger is too low. But of course, I don't see them very often either. People very rarely bring these motions anymore. So is the goal to keep fighting over this and, you know, taking your chances, and then I have to award sanctions one side or the other? Or would Mr. Charnitsky, maybe you want to withdraw your motion with prejudice, and then Mr. Schneider, maybe you can agree not to pursue sanctions against him? Or is that something that is something you guys would be willing to consider, or do you want to just keep fighting over this and take your chances?
Your Honor, with due respect, we believe that there is sufficient evidence solely in the timing of what happened, and we don't need to necessarily bring in the settlement discussions per se. I mean, even just admitting evidence that there was a threat of a motion for summary judgment, and immediately after that, the the suit was withdrawn, the suit was non-suited. We have provided case law in our motion that has found that that is on its own sufficient. Now, we believe that there is extraordinary evidence in the settlement discussions of a bad purpose, of an improper purpose. If those are not admissible, certainly we're not thrilled with that result or that ruling. But nonetheless, the fact remains that there were special exceptions granted. There was a repleading. There was a threat of motion for summary judgment after the repleading. And immediately after that, the suit was withdrawn. Now, on its face, that's sufficient to grant sanctions, and we've provided case law to show that. We would prefer that the settlement discussions get in because we believe that there's significant evidence of them of the very, very specific improper purpose. But nonetheless, on their face, the sequence of events that is readily available in the record is sufficient on which to grant sanctions.
I'm not ruling on anything right now. I'm just asking the question. If you guys want to keep fighting over this, you had asked to withdraw the motion and to refile it to allow for additional briefing. Mr. Schneider is opposed to that. I think there's a risk to both sides here that if you keep fighting over this, that, you know, I think there's at least some chance that Mr. Cherniske, your client, could be sanctioned. There's obviously some chance that Mr. Schneider's client could be sanctioned. But if you guys want to, you know, I don't know that I can stop him from withdrawing his motion without prejudice and refiling. And I guess the main question I have is just, let's see, you have in your response, I guess, to motion for sanctions, you've requested sanctions. Let me just take a look at that.
Your Honor, I think the way to understand our opposition is that we didn't request sanctions. We requested that the court consider awarding the reasonable expenses and attorney's fees incurred opposing the motion because plaintiff, we believe, will be the prevailing party and is entitled to the costs, just like is sometimes sought on motions to compel. It's not because it's a sanction, it's because the statute awards us that entitlement and gives the court the ability to award the attorney's fees to the prevailing party. So I'm not characterizing it as saying that plaintiff has sought sanctions against Mr. Cherniske. We have not sought sanctions against Mr. Cherniske. We have requested recovery of our attorney's fees and expenses incurred opposing the motion if and when we are the prevailing party on the motion.
So given that, I guess my thought is that we would, he would have a right to withdraw the motion at this point. You have no counter motion for sanctions. That's kind of what I was trying to think through, is if you have a counter motion for sanctions, then we could hear your counter motion. If there is no counter motion, he could withdraw this, and then if he wants to refile it and take his chances, he can, you know, I don't see how I can force him to bring the motion. I guess you could file a counter motion for sanction at some points if you want to keep fighting over this, but until there's a determination that you're the prevailing party, I can't work sanctions on your behalf. And if he's withdrawn the motion, then I don't have the ability to make that finding, I guess is my thought. Does that make sense?
It makes perfect sense, Your Honor, and I don't think I disagree with the court's reasoning and statement of what it can and cannot do at this juncture.
So, Mr. Cherniske, what do you want to do? Do you want to withdraw it for now and then make a decision later, or what do you want to do?
Your Honor, and I would just say with the note that plaintiff's contention, somewhat stunningly, is that if we withdraw this without prejudice now, it's de facto evidence that this was brought in bad faith, which is exactly the argument that they're arguing against with respect to the motion for sanctions. That being said, if the court is not going to admit testimony on the settlement discussions. We would like to brief that issue, and we would withdraw without prejudice the motion for sanctions and refile later.
I think he has the right to do that. I would urge you to consider strongly the court's admonition that this may not be a good idea for your client to pursue, but you obviously have the right to do that, and I'll make rulings as appropriate. And if you are able to carry your burden to establish sanctions, then of course I will grant them. And if you're not, then I will have to award sanctions again, or attorney's fees and costs if the non-movement is the prevailing party. So anything else, guys?
No, Your Honor.
No, Your Honor, thank you.
All right, you guys have a good day. You be safe, okay?
You too.
Thank you, Your Honor.
Thank you.